Okay, the appeal we have to be sitting at the Board of Appeals this evening. So the appeal is Friends of Historic Bristol, Inc., William C. Curtis, James S. and Jane L. Lavender, Leonard Place and LLC, and Lee Jensen. Appeal of the planning board decision dated May 16, 2022, approving a major land development project master plan for the Bristol Yarn Mills, aka Robin Road, submitted by Bradley Sullivan Properties, LLC, for the redevelopment of existing mill building into mixed-use property with 127 residential dwelling units and 6,300 square feet of commercial space. Okay.
Okay, I'm gonna maybe guide the Board of Appeals as to the process. My name is Matt Oliverio. I'm an attorney from North Kingstown, and I'll be representing the Board of Appeals this evening. So members of the board, as an appeal, this is being taken pursuant to your local ordinance, section 28410, which is appeals to the zoning board. And this is from a decision dated May 12, 2022, from the planning board granting conditional master plan approval of the applicant's major land use development plan. The standard that you're going to apply tonight, the record, the hearings, the evidentiary record has already been made at the level of the planning board. So a group or individuals with standing has now appealed that in a timely manner to this body. And your task is not to substitute your own judgment for that of the planning board. Rather, the standard for you is to make a decision to determine whether or not the planning board in their deliberations and decision-making process, if their decision was affected by prejudicial procedural error, clear error, or that their decision is not supported by the weight of the evidence in the record below. And you have before you the entire record of the planning board relating to conditional master plan approval. So again, no new evidence will be admitted here. You're sitting more or less as an appellate body. After you hear argument from the representatives of the party, so you'll hear argument from Mr. McGilvery. He's an attorney who represents a number of all of the appellants, I believe. He will present his position to you. They've briefed it, but you allow him to make argument. Then you can ask questions of Mr. McGilvery to clarify any issues. I'm here to assist you. And then following that, the applicant's attorney, John McCoy, will present argument. We'll go through the same process. You can ask him questions, seek clarification, and then the planning board is represented by your solicitor, in this case, Andrew Tights, and he may also make a presentation, and again, you can ask questions. Following those presentations, you can deliberate among yourselves in public, and you have to justify the decision that you're going to make here based on what's in the record, the arguments of counsel, and come to a reasoned decision. Now, your decision can end up being, a variety. You can reject the appeal, you can accept the appeal, you can modify the decision of the planning board, you can send it back for further proceedings, and that's all laid out in the ordinance. So my suggestion is that we begin with the appellant's counsel to lay out his case before you. And I would ask that Mr. McGilvery, I know that he submitted a memo of law, but I think it would be helpful to the lay board here if you can go through each of the grounds upon which you seek reversal of the planning board decision. Is that okay, Mr. Chair?
Yeah, I have one question for you.
Sure.
Could you do one more thing? Could you just explain all three standards for everybody so they know what everything is prejudicial error, whatever, so everybody's on the same page here?
Yeah, prejudicial procedural error is an error that something happened in the process below that is so prejudicial to the appellants that it cries out for reversal, okay? So, and I think they argue some of those grounds, and you just have to determine if that is the case, and you have some memos on that as well. So you have some arguments and counter arguments, and again, I'll help you navigate through that. Clear error is, I'm trying to think of the standard under the case law, and maybe Mr. McGilvery and Mr. Tice can help me out with that. In review, if their decision lacks support in the evidentiary record, you look at the minutes from the meeting, you look at the exhibits that were submitted, you listen to the argument, the public hearing, and you weigh all that. And if you determine that the better weight of the evidence or some of the evidence supports the rationale and the decision of the planning board, then you should affirm that decision, okay? Unless there's clear error or prejudicial procedural error, okay? So it's kind of an amorphous standard, it's a legal standard. You kind of know it when you hear it and see it, and that's why I'm here to answer any questions. But I'll defer to Mr. Tights.
Well, I don't want to start because everybody else might want to say the same thing, but just for the record, Andrew Tights, and I'm here tonight representing the planning board. But I think I want to clarify, or at least put in my 2 cents on the weight of the evidence, because it's really the same standard the court would apply when looking at one of your cases that goes up to appeal. So it's not that you weigh and say, oh, let's see, well, the planning board only had 45% of the evidence on their side. It was 55% on the objectors, therefore it's against the weight of the evidence. All you need and can find is the standard is more than a scintilla, but less than a preponderance. So basically anything like over 5% up to 50%. If you see that, if that evidence is supporting the planning board's decision, it doesn't have to be a preponderance. In fact, the law says it need not be. Just that there be that substantial evidence, more than a scintilla, to support the planning board's decision. So,
And I think that's consistent with the case law, because preponderance is a civil standard in a civil case, and the courts, the Rhode Island Supreme Court has exactly ruled that a scintilla of the evidence. So it's kind of in between, something less than preponderance, but more than
nothing.
More than nothing.
Thank you.
So, Mario, you didn't mention a provision for public comment. Is there a provision for public comment?
No, there's no provision for public comment, because that was all had at the planning board stage. No, this is an appeal, and you'll hear an argument. These are legal arguments. So public comment, there was opportunity at the planning board stage. And when you serve as a zoning board, you're used to having public comment. That's on an application for a variance, for instance. This is different. You're sitting as a board of appeals. A record's been made.
So we'll only be hearing from the attorneys this
Correct.
evening?
That's correct.
Thank you for the clarification.
Sure.
Okay, great, pretty good. Everybody all set? Yeah. Okay, let's begin.